Blake Lively is handed a loss by the judge. The New York Times is trying every which way to get out of the case. Lively is also hiring a former CIA alum, and a co-star is speaking out. A lot of updates we got to get to when it comes to the ongoing legal saga of Justin Baldoni. Okay, so we got a bunch of new updates we got to talk about in the Baldoni-Lively legal fight. Haven't talked about it in a minute. So remember, Lively has sued Baldoni, her co-star director of It Ends With Us, his production company, Wayfair, executives, his PR and crisis management experts, his team, alleging that Baldoni sexually harassed her and then launched a retaliatory smear campaign against her. And then Baldoni fired back in a lawsuit of his own against Blake Lively, her husband Ryan Reynolds, also suing the New York Times, arguing there was a coordinated effort to destroy his reputation with false allegations that were weaponized against him for Lively to take control over the movie, take control over all aspects of production. That's more of a generalized summary, but at this point, I'm sure all of you know the back and forth. Okay, now we got to go into the updates. First up, we're going to start with the fact that Blake Lively was just delivered a blow by the court. Now, if you've been following us here on Sidebar, you may remember that whole subpoenas issue we talked about. It was reported several weeks ago that Lively's legal team sent out a bunch of subpoenas to cellular provider companies like AT&T, Verizon, T-Mobile. Her attorneys, Ezra Hudson and Michael Gottlieb, said in a statement that was published in The Hollywood Reporter, quote, "Ms. Lively has initiated discovery that will expose the people, tactics, and methods that have worked to destroy and bury her reputation and family over the past year. We will now receive all of the receipts that, unsurprisingly, are nowhere to be found on Mr. Friedman's website. And like Ms. Lively, those receipts will have their day in court." And that is a reference to Baldoni's attorney, Brian Friedman, and the website that was purportedly launched by him and Baldoni's team, featuring an amended complaint in the case, their version of a timeline of events in the story. It featured never-before-seen text messages between Baldoni and Lively and Baldoni and Reynolds. Now, the lawyers for Baldoni & Co., they filed a letter with the judge overseeing this case, the Honorable Louis J. Lyman, and they argued that these subpoenas from Blake Lively, they are way too overbroad. They claim that Lively was seeking, quote, "all documents concerning ingoing and ongoing calls or text messages related to phone number," then it's redacted, "belonging to each of the individuals, Wayfair parties, some of their employees, various non-party individuals, including but not limited to call logs, text logs, data logs, and cell site location information." They argued that the subpoenas seek such information over a period of multiple years, in most cases spanning from December 1st, 2022 to the present. And they wrote in their letter to the judge, "It is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. This would include, of course, materials protected from disclosure by a laundry list of statutes and privileges, among them the attorney-client privilege, the spousal privilege, and the physician-patient privilege. Moreover, the information sought by the subpoenas is widely disproportionate to the needs of the case and unnecessarily invades the privacy of untold numbers of third parties, including family, friends, business partners, and quite literally any other person with whom any of the targets have communicated with over a period of years." And they called this, quote, "a flagrant abuse of the discovery process." So they had a major issue with these subpoenas. Now, Blake Lively's side responded, and they argued in their own letter to the court, quote, "The Wayfair parties have sued Ms. Lively for a preposterous sum of $400 million for claiming that a retaliatory campaign existed, yet now appear to fear having third parties turn over the actual evidence that would document the who, what, when, where, and why of that campaign." On February 12, 2025, the Lively Reynolds parties issued notices of the subpoenas to the aforementioned carriers seeking non-content records, that is, numerical logs related to 15 specific individuals. Each individual is either a party to this action or is an agent, employee of a party who appears, based on evidence discovered in this case, to have a direct connection to the underlying issues. The requests are tailored to the time during which evidence shows each individual may have been involved in acts giving rise to Ms. Lively's claims. Such information is not only relevant, but essential to unearth the network of individuals involved in the alleged retaliation scheme against Ms. Lively. And to add a bit more to that, later on, it is emphasized a bit more, quote, the Wayfarer parties misrepresent both the nature and the scope of the subpoenas, inaccurately stating that they seek spousal communications, medical information, attorney-client communications, among other things that could infringe on privilege. The requests do not seek the content of any communication, only call, text, and data logs. The Lively Reynolds parties have not sought and do not seek here anything other than non-content records as permitted by law. The Wayfarer parties have cited no authority from any court in any jurisdiction to suggest that such subpoenas would be improper. And they argue that courts have held in the past that this type of information, namely, identifying information or something, proving something exists or proving a conversation happened, that is not protected by privilege. And again, it's not the context of the communications that they're seeking right now. And they argue that Baldoni, Wayfarer, they have not explained how any of that information they're looking for implicates any medical privacy issues. And finally, Lively's counsel addresses another point, Wayfarer's argument that third parties' privacy concerns could be impacted by these subpoenas. Well, Lively's counsel argues that doesn't work because Wayfarer and the other parties, they don't have any authority to make that objection. That's up to the third parties to stand up and say so. They have no claim or interest in those communications. We call that in the law standing. Essentially, they have no standing to make that objection, that they're not the ones being potentially harmed or affected. That's the third parties or the non-parties in this case. If they have a problem, they should object. And Lively's lawyers also argued that if Baldoni and Co. had legitimate concerns here, why not move quickly to put a protective order in place? Okay, so what did the judge just decide? Remember I said Blake Lively was just handed a loss? Well, the judge ordered that Baldoni and Co., their motion should be granted in part and also denied in part. Let me explain. So the first thing the judge did was explain that there's been an update in this case, and that was that after the parties, both sides, met and conferred, Lively actually agreed to narrow her subpoenas. She agreed to remove the reference to all documents, she agreed to remove the request for locational data, and she agreed to clarify that the subpoenas seek only call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing text messages, and that Lively has prepared updated, modified subpoenas with these changes. However, apparently, Baldoni and Wayfarer, they continued to object to the subpoenas, arguing that the subpoenas will improperly reveal the phone numbers of anyone with whom they communicated, whether it was related to this case or not. So they countered that the subpoenas should only be limited to communications between the phone numbers and the phone numbers of parties in the case and witnesses that Lively intends to call at trial. And it seems the judge has agreed with Justin Baldoni and Wayfarer and Co., writing in his order, quote, the subpoenas of the Wayfarer parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests. Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer party spoke to and when. And the judge found that Lively hasn't shown how she would actually separate those numbers that may be relevant to the case from those that wouldn't. And the judge doubled down that even if someone doesn't have a privacy interest, let's say under the Fourth Amendment, a protection against unreasonable searches and seizures, parties still have a privacy interest in their phone records under state or federal law. And Baldoni, Wayfarer, they have a privacy interest in their communications with non-parties. And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023? And then the judge writes, quote, Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfair party's privacy interests. So the subpoenas are thrown out regarding the extent they seek phone records of Wayfair parties. But that doesn't mean this is a total win for Justin Baldoni and co. Why? Because the judge indicated that Lively could make discovery requests for more specific evidence and information tailored to specific people in the case, basically meaning be more specific, be more precise about what you're looking for. And, Blake Lively, you may be able to get what you want, but also the judge sided with Blake Lively's argument that Baldoni, Wayfair, they don't have standing, they don't have the legal authority to object to the subpoena request for phone records of non-parties, meaning, again, they don't have standing to object. So in other words, Baldoni, Wayfair, you may have a privacy interest in your own phone records, but they haven't provided any basis for why they have some sort of interest or privacy interest in the communications of non-parties. So the Wayfair-Baldoni motion to quash the subpoenas for that information was denied. Lively won that one. But we got a response from Brian Friedman in a statement to Fox News Digital. It says, "The court put a stop to Ms. Lively's egregious attempt to invade our client's privacy. This is a big win. No matter how the Lively parties may try to spin this decision, the court saw their efforts for what they really are, a desperate fishing expedition intended to salvage their debunked claims long after they already savaged our client's reputation in the New York Times." Now, we also heard a response from Blake Lively's side. A spokesperson for Lively told Fox News Digital, "What is Brian Friedman hiding? After promising to release all the receipts, Friedman ran into court to keep secret the phone records of who Baldoni, Heath, Sarowitz, Nathan, Wallace, Abel, these are all parties in the case, were calling during their retaliatory campaign. So instead of getting these records from the phone carriers the way we initially requested, the judges ruled that if we simply submit more specific requests, we will be able to get the records we're seeking. Today, we will do that. We are submitting those requests directly to defendants involved, and we look forward to seeing the records." Okay, so that is only one update in this case. We got some more we got to talk about. The next one concerns the New York Times. Now, again, Justin Baldoni sued the New York Times, claiming that they published an article right after Blake Lively filed her initial civil rights complaint with the California Civil Rights Department. And Baldoni argues that that article from the New York Times was one-sided, that it didn't provide the whole context of communications, that this was sloppy reporting, that this was defamation. But here's what happened. The New York Times has just filed a motion to dismiss Justin Baldoni's lawsuit. Again, when he sued them for defamation, false light, fraud, breach of contract for publishing the article about him. And they make a number of legal arguments that we're going to get into right now. So first thing they write, the only thing the Times is, in fact, alleged to have done is engage in news gathering and publishing an article and video about the Wayfair-Lively dispute. The Wayfair parties have failed to allege a claim against the Times, and this court should therefore dismiss the FAC, the First Amended Complaint, as alleged against it pursuant to Rule 12b-6. Now, Rule 12b-6, that authorizes a court to dismiss an action at the very beginning of a lawsuit. If you take all the facts as true in the complaint, the plaintiff failed to state a claim upon which relief can be granted. In other words, there's no viable legal cause of action here. It has to be plausible that there's something here, that there's really no case. That's the argument. Now, the New York Times stresses that federal courts, they have found that in defamation cases specifically, because there is a risk of chilling First Amendment freedoms, courts should try to resolve these claims at the initial beginning pleading stages if possible. So why do they claim they're entitled to a motion to dismiss? Well, first off, the New York Times argues that all Baldoni's amended complaint does is lump in the New York Times with the rest of the defendants. Problem is, that includes acts that were before the publication of the article by the New York Times. And they claim that under the law, this is improper group pleading under the federal rules of civil procedure, and the complaint should be dismissed, particularly if this creates a great burden on the defendant. Quote, the Times must parse the Wayfair party's extensive verbiage, much of which does not relate to the Times at all, to discern their claims. This vague, convoluted pleading, which fails to properly allege what the Times actually said, whether it was false, and whether it was published with actual malice, is impermissible under Rule 8. It is all the more unacceptable because plaintiffs have already amended their allegations against the Times and therefore had the opportunity to fix their pleading problem. So first, the Times argues the defamation claim fails. So they cite how it seems that the only allegedly defamatory comment made or attributed to the New York Times is from a video that accompanied the article in which one of the writers, Megan Twohey, summarized the article. The statement was, quote, "The men, Baldoni and Heath," Jamie Heath, this is the CEO of Wayfair, "hired a crisis PR manager, Melissa Nathan, who orchestrated a smear campaign against Lively." Now, the Times argues this is not actionable defamation. There's no liability here. They argue that that statement is absolutely privileged by New York's Fair Report Privilege Law, which, quote, "protects any fair and true report of any judicial proceeding, legislative proceeding, or other official proceeding." Now, in order to meet this, the report must give a substantially accurate account of a proceeding or official document. And also, the report must attribute its allegations to that document. And here, they argue they've done just that. So they argue Lively's initial complaint with the California Civil Rights Department that they wrote about is an official proceeding, and official proceedings can include legal filings like this. Then they argue both the article and the accompanying video attribute the allegedly defamatory material to the complaint, to the official proceeding. Quote, "There is no real dispute that the article reports on the CRD complaint. The article consistently uses language like, according to a legal complaint, and the CRD complaint claims, to describe Lively's allegations about the Wayfair parties. And the article quotes extensively from texts and emails between Baldoni, Heath, Nathan, and Abel that are reproduced in CRD complaint." But the Times also argues that the article and the video, they fairly report on the CRD complaint. That it, quote, "accurately summarizes the CRD complaint in regard to the sole defamatory statement alleged by plaintiffs that they engaged in a smear campaign. The article and video summarize the filing's allegation that Baldoni engaged Nathan and Abel to tarnish Lively's reputation in retaliation for complaining about Baldoni and Heath's purported misconduct. The term smear campaign, though not used in the CRD complaint, is a fair and accurate shorthand way to summarize the main thrust of the allegation supporting the allegations of retaliation." And the Times claims that Baldoni, Wayfair, their arguments that the Times is not protected by this privilege doesn't work here. Quote, "First, the Wayfair parties contend that the Times, colluding with Lively, was given her CRD complaint prior to filing. Even were that so, receiving an advance copy of an official document before filing doesn't obviate the privilege. As this court has held, even if a journalist is passed a copy of the complaint by the filing party, that would not prevent the journalist from reporting on the complaint or deprive her fair and accurate report of the benefit of the absolute privilege accorded it by New York law. Second, the Wayfair parties hint that they believe the article and video are not privileged because the Times made little or no attempt to investigate the veracity of Lively's allegations. That is not so, but the argument exhibits a fundamental misunderstanding of the privilege and its purpose. The point of the privilege is that journalists should be free to accurately inform the public about official proceedings without having to fact-check them. The public has an interest in learning about a filing, true or false, misguided or well-considered, that is made to a public agency. Finally, the Wayfair parties claim that the article and the video should have included the reasons why Nathan was hired to bury Lively. Once again, plaintiffs exhibit a deep misunderstanding of the privilege. While the Times sought and published the Wayfair party's response to the complaint as a matter of long-standing Times policy, the privilege itself imposes no obligation on a publisher to tell both sides of a story. The obligation is to report fairly and accurately on what is actually in the public filing, nothing more. So in other words, because all of this is privileged, there's no actionable defamation claim. And the Times also argues that even if there was no privilege, the actual allegedly defamatory phrase that's of issue here is a constitutionally protected statement of opinion, not fact. They argue that the phrase smear campaign is rhetorical hyperbole and that it doesn't have any clear-cut meaning. And this is a colorful judgment or a colorful conclusion that is based on the disclosed facts presented in the complaint. Like where Baldoni wanted, quote, a plan to combat steps taken by Lively, that he was unhappy with the initial proposal provided by Nathan and Abel, that Baldoni wanted to, quote, feel like she can be buried. And also the Times argues that Baldoni and co., Baldoni Wayfarer, they haven't plausibly alleged in their complaint that the published article was made with actual malice. So when you're dealing with public figures in a defamation case, you have to prove that the defendant published a false statement either knowing it was false or with reckless disregard for the truth. So here, the New York Times argues if you look at Lively's complaint, there's real evidence. There's text messages that arguably show or prove a smear campaign was existing, that a reasonable reader could conclude that this allegation was true. So they again argue that the defamation claim fails, and that is a key cause of action in this complaint. Obviously, Justin Baldoni and his team will have a chance to respond to this, right? But what you're seeing is why it's notoriously very difficult to win a case against a publication because of these arguments. That is why defamation claims like this sometimes don't make it past the initial pleading stage and are dismissed. So let's see which way this goes. But now, that's not it. Because the Times also argues that this complaint should be thrown out against them because the other claims fail as well. And that's why the complaint needs to be dismissed. So they argue the false light invasion of privacy claim fails because they assert New York, not California law applies to this case. And there is no New York false light invasion of privacy. Next, they argue the promissory fraud and breach of contract claims fail too. Now, this is based on the idea that the Times allegedly promised to hold off publishing the article until noon on December 21st, but ended up publishing it earlier. So the Times argues, first, by law, if you have a contract and fraud claim based on the same thing, the fraud claim has to be thrown out because it's been held to be redundant by courts. It must be stricken. The breach of contract claim, the New York Times argues, that fails as well because they assert Miss Toohey of the Times actually emailed Jennifer Abel, this is Baldoni's publicist, the day before the article was published, offering until noon the next day to respond, and Abel did respond to Toohey's questions that night and indicated this was on behalf of Baldoni and the other parties. And the Times claims that Abel never indicated there would be more to this response, and the Times cited that response in their piece and in the video. So they mentioned what the response was from Baldoni's side. In other words, there was no breach of contract here, and there was never any promise to wait to publish the piece. So because of all of this, the Times claims that the complaint should be dismissed and they be removed from this case. We'll see which way that goes. Now, we are not done talking about the New York Times yet because we have another update too. So, the New York Times also filed a letter with the court asking to pause discovery in the case, where each side turns over potential evidence to the other side. They're asking to pause discovery until the court rules on its motion to dismiss, what we just talked about. And they also indicated that nonetheless, they will provide initial disclosures by March 14, 2025, but they want to pause discovery. So, the Times explains that when the court first set a deadline of August 14, 2025 for the end of all fact discovery, the Times wasn't even served the first amended complaint yet. That if that was the complaint that officially added them as a defendant in this consolidated action with Blake Lively. And they cite how the court remarked at the time, quote, as to the New York Times, it's not unusual for parties to be added in. I would hear from the New York Times once they have been served and make an appearance. It may result in the case management plan being changed. And the New York Times claims in their letter to the court now, the Times seeks to take the court up on its offer to ask to alter the case management plan. And the Times argues there is good cause or good reason for why they should be granted their motion to pause or stay discovery. So first, they argue this case involves First Amendment issues in a defamation situation. And there are prior defamation cases where a stay of discovery was granted. Although, after looking at what they cite, I can't be 100% certain if those cases, the discovery was paused because of the nature of the case, because it was a defamation action, or because those just happened to be defamation cases where discovery was stayed for other reasons. I couldn't be 100% sure. But the Times has other arguments as well. They also argue that a stay of discovery is appropriate when the motion to dismiss has, quote, substantial grounds. And here they argue their motion is meritorious. And that's because of all the arguments that I went into detail before. Third, the Times indicates that discovery in this case is going to be expansive, it is going to be expensive, it is going to be complicated, and instead of the Times having to go through all of this now, which can involve specific issues of confidential sources and specific laws related to journalists, why not just pause discovery until we know for sure this case is going to move forward against us? Fourth, the Times argues that a stay of discovery would not create undue prejudice on the parties because other parties in this case, they're already exchanging documents. They can go forward. You don't need the Times yet. So the Times is asking for a pause in discovery until the court rules on its motion to dismiss. Or they also offer this. They ask the court in the alternative to extend the discovery schedule by 1 month because they entered into the case later than the other parties. Now, Wayfarer and Baldoni responded in a letter of their own, objecting to the Times' request for a stay. And after citing various case law and the standard on when courts should or should not grant a stay of discovery, this is how they reason it. First, they argue that the Times hasn't shown that the discovery is going to be so voluminous and expansive and burdensome and expensive as they claim. They say no discovery demands have even been made yet. And they also argue how the New York Times argument of, well, we don't want to litigate complicated issues related to discovery if the case won't even proceed. Well, Baldoni and Wayfarer argue if that were the standard, then no discovery would proceed in a case where there's a pending motion to dismiss. The law doesn't work that way. Second, they address the Times' claim that Baldoni and co., they won't be unfairly prejudiced, but Baldoni and Wayfarer, they say we don't know when the court will decide this motion to dismiss, so just pausing discovery for an indefinite period of time, that's an issue. Third, Baldoni and Wayfarer, they argue the Times' motion to dismiss doesn't affect this whole case. It can still move forward with a number of parties. It doesn't end with the Times being removed or not from the case. And Baldoni and Wayfarer argue that they will seek the court's permission to amend anything in their complaint that needs to be fixed based on issues that were raised by the Times in their motion to dismiss, and therefore that weighs against a stay of discovery. They write, quote, "We respectfully request that the court deny the Times motion for a stay of discovery. At a minimum, document discovery with the Times should proceed, and the court should stay that party's deposition only pending its motion to dismiss." Now we'll see how all that shakes up. But before I let you go, just a couple more updates I want to talk to you about. So first up, apparently it's being reported Blake Lively is staffing up. So according to Variety, she has hired Nick Shapiro to her team. Now he is a former CIA Deputy Chief of Staff, and he was the senior advisor to former Director John Brennan. One of the members of her legal team released a statement saying, "The litigation team for Miss Lively retained Mr. Shapiro to advise on the legal communication strategy for the ongoing sexual harassment and retaliation lawsuit occurring in the Southern District of New York." Perhaps, maybe that's about what can and should be said in the media as this litigation persists. Maybe it's about how both sides have to communicate during the course of this litigation. Not entirely sure. But one more update I want to talk to you about is one of the former cast members of the film It Ends With Us is back in the fray, back in the news. Brandon Sklenar. Now, he played one of the love interests of Lively's character, Lily Bloom, in the film. And now we've talked about it before, because after Lively filed her civil rights complaint, he shared a link to that New York Times piece, more specifically Lively's complaint, on his Instagram. And he wrote this: "For the love of God, read this." He also tagged Lively's social media handle and included a heart emoji. But here's the thing, as reported by People, he was just asked on Sunday at the Vanity Fair Oscars party about this legal drama going on between Justin Baldoni and Blake Lively. This is how he responded. "I mean, it's a tough situation. I just hope everyone remembers what the movie is about and why we made it in the first place. It's about love. It's about supporting women in general and helping people through tough times," because this is a film about domestic violence. Going on to say how the film helped so many people. And then he said, "I just want people to remember what it's about, why we made it, and to kind of keep it on that kind of like core ethos. You know what I mean?" And by the way, this comes after his appearance on CBS Mornings last month, when Gayle King asked him if he's Team Blake or Team Justin, to which he responded, "I'm Team It Ends With Us." Interesting, because he could be a potential witness in this case if it goes to trial. But that is all we have for you right now here